So this one's live on YouTube and it's live on Collaborate, and we're going to kick it off with sharing on the screen agency and trusts. Now, historically, this subject didn't talk a lot about trusts, although the textbook did. It talked about agency largely. I think agency is actually a very minor point, to be honest. I don't think it even, I mean, maybe deserves one chapter. But I do have to note that but trusts are a huge part of the common law system. And I was really disappointed when I undertook a law degree to realize how little I was taught about trusts in my business degree at the University of Auckland. And I didn't really know how they worked. And so I'm hoping that today I can impart on you guys a bit of an understanding on how these particular structures work, because they are a big part of life. They're a big part of the accounting profession. They're a big part of business. And knowing the rules is hugely, hugely important. It's a very, very powerful thing. Now, we're going to start though with the superset. Agency and trusts are actually subsets of a greater category that we have been exposed to a little bit earlier in the subject. Is the idea of the fiduciary. The fiduciary is a type of duty that involves usually a stronger party and a weaker party as part of that. And it's basically a duty that is imposed in the area of law known as equity, that is there to ensure that the stronger party doesn't do bad things to the weaker party. Okay, and I've talked about it in that case in the mid-1980s, the hospital products case, because it's something that it's quite unique to the British system, the idea of the fiduciary relationship. There are other systems do have something similar. I think Heaney might be able to correct me on this. I think it's Waqif. Something I probably mispronounced that in Sharia. But there's nothing really comparable to it in the civil jurisdictions. And again, Enrico and Co can correct me on this, Kuyen, because the idea of this area of law sits outside of statute and common law. It's equities designed to remedy defects in the law, and it's deliberately left open-ended and fluid. Okay, now, fiduciary relationships come in two flavors. The most important one for our concern is what we call status-based fiduciaries. They are people who are assigned particular roles by virtue of the position they're in. And so the two we're going to look at today are agent principal and trustee beneficiary. The idea is, and it seems a little bit unintuitive, but in that list on the screen, the powerful party is on the left and the weaker party is on the right. So just have a little look down that list. Does anything there look a little odd to you? Partner, yeah, that's one. The other one that I remember when I was taught this a long time ago now, the other one was employee-employer. Strange that we don't usually think of the employee as being the powerful party in the relationship. All right, but in the context of fiduciary relationships, the employee is the one that has all of the employer's secrets. The employee is the person with the ability to do bad things to the employer. That's not to say employers don't have certain duties, other duties, but they come from other areas of law. They're not fiduciary duties in nature. Now, the Fair Work Act might impose duties on employers, for example. Business partners, so people in a legal partnership, are essentially able to really do bad things to each other, because in a partnership you're actually all liable for all of the contract things that a person does, both in contract and in tort. So you can be liable when one of your business partners goes and buys $1 million house in the scope of the partnership, using partnership funds. The rest of you, assuming that person goes bankrupt, have to pay which is a little bit scary. That's the concept of unlimited liability. That's why business partnerships are, in many ways are fraught with danger. Um, some of them I'm not going to go too much into today. Solicitor client is a situation where, again, the solicitor is entrusted with the client's secrets and information is given to them in confidence. A lot of these fiduciaries, in terms of the power dynamic, is to do with information. The bottom one, executor and beneficiary, that's a person who is vested legal title of stuff after a person dies. They're given a job to take care of all the stuff, determine what it is, and then distribute it to the beneficiaries after this period known as probate has passed. The two that we're concerned about here are the top two: agent, principal, trustee, beneficiary. They are two established categories of fiduciary duties. Now, fiduciary duties have these general principles that are going to apply to all of those relationships. One of them is to avoid conflicts, so that if you are an agent and you're, for example, if I'm employed as an agent to go, and I'm tasked with the job of going to Ingham to purchase purchase a house for Enrico, all right, and Hannah calls me up and says, "Oh, can you go to Ingham and buy that house? Oh, and you're doing it for Enrico as well. Okay. How about you pay an extra $5,000 so it goes to me, and I'll if you if you get me the house instead of him, I'll pay you an extra $5,000." All right, that's called a secret profit, or I suppose exactly, it's also a bribe as part of that. And that is arising from a conflict of duty where I've got multiple fiduciary relationships. Solicitors have this a lot. And so that there is a very structured series of rules when you take on a new client. I missed that. I'll come back to that. As a solicitor, if you take on a new client, there's actually software that we go through and search to make sure that the new client hasn't been one that we've worked against in the past. Or for this particular client, the person that they're trying to sue, we haven't worked for in the past, because that's going to create some conflicts for us. And we are barred both in terms of a statutory framework under the Legal Profession Act, but we're also barred. We have these fiduciary duties to try and avoid those conflicts. Okay. Later on today, I'm going to talk about these things, this breach of fiduciary duties. When people actually do breach confidence, they don't maintain confidentiality, or they do go and make secret profits or take bribes. And I'm going to talk about a variety of cases. And I think at the very end of the session, I'm going to talk about Yu-Yang, which you guys as accountants are probably going to find fascinating, because the level of duty that a fiduciary relationship places on you is one of the highest that arises in our legal system. It is far higher than the duties that you have in contract and in tort, and certainly a lot higher than bailment, which we do next week as well. The duties that are placed on you by a fiduciary relationship are very high indeed. And so they're not the sort of thing, because they're an equities jurisdiction, that you can try and come up with some secret way or loophole around. One of the upsides of equity is that by its very nature, there aren't loopholes. Okay? Just try and say that again. The very nature of equity as a court of conscience is to, when parties do come to the court, and they can only do these things while inside the court, it's to try and resolve things that can't be resolved by looking at your strict common law and statutory rights. As part and parcel of that. So as a result, it doesn't really work in terms of loopholes. Try to supposedly clever ways to get out of obligations. Okay, so we're going to quickly look at agency. Now, I've just got to note this. I couldn't believe it when I was reading the textbook a couple of weeks ago, and I read for those that have got this version of the book. 15-5. I'll see if I can hold it up. I might actually be able to hold it there. 15-5. Loop, 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 loop. How far down is it? It's about there where my finger is. All right. I don't know if you can read that on the screen there, but the first paragraph, first sentence, in fact, it says the authority component of the relationship can be actual implied, comma, which is also described as ostensible. That is wrong. It's just wrong. So that everything after the comma you can just cross out. I looked at it and read it, thought that doesn't seem right. And so I called up Stephen Graw, who's the primary author of the book, asked him if he wrote it, and he didn't. One of the other authors did, but he's taking it over for next time. So that chapter will be rewritten. So feel free in that book to just cross out everything after the comma, because it's just flat out wrong. Okay. Agency is the ability in our legal system to give somebody authority to act on your behalf. It's that kind of simple, really. It's basically you as a natural person or as a corporation have the ability to let others do things on behalf of you. And if you actually think about it, with corporations, all people involved in a corporation are agents. Why? Because corporations don't physically exist. Everybody is acting on behalf of the corporation. And again, often with multiple roles, either as company directors or as employees, but the company can also appoint agents directly as well. Okay, and this key thing there, Scott and Davis, agency binds the principal, which is the I guess the weaker party, the one who's wanting to appoint the agent. It's going to if an appointment is valid, it's going to bind the principal in both contract and in tort. And so a person, and I mentioned this when we talked about vicarious liability last week, an agent acting within the scope of their agency, much like an employee acting within the scope of their employment, is going to render the employer, and in this case the principal, liable in both contract and tort. This is how other people, it sounds like a good thing to be able to appoint an agent to do something, but if they do something bad in the scope of that, you are going to be held liable. It's essentially how our agency works. And once you've got your head around it, there's really not much to it. I was never quite sure why agency took a full 3 hours to go through. Okay, so there's some different types of agents. You can appoint people to as an agent for just one transaction if you want to. So again, Enrico appoints me and says, Simon, drive to Ingham and buy me this house at this address. There's an auction. I want you to go to that auction. Don't spend more than $200,000. Thanks. Cool. All right. Now, that is a single transaction. There's no other transactions. And that is what we call, in this situation, a special agent. Special agent, it can be one or a series, but a finite number of transactions, we call those special agents. Whereas if it's an ongoing relationship, so you can act as my buyer every time I buy a house to go through and do that. They're known as general agents. And there's also another category known as universal agents. That usually applies to things like powers of attorney. You can under the Power of Attorneys Act, actually appoint somebody to do everything, either involved with your finances or involved with your health or both. And they have universal power to act on your behalf. They can spend your money. They can buy houses. Yeah, total power of attorney. That's essentially that, yes. We call that a universal power of attorney. They're called universal agents. And as I said, that's the that's my slide, so I've got to get to the habit of flicking it over. Yes, Tala.
So a personal question, but I think it will help the class. So
Sure,
I've
sure.
given my father a power of attorney to do anything and everything as long as I'm alive. And that was done ages ago, and now I live in Australia.
Yep.
With that, like if anything happens or I need him to act on my behalf, can he do that even here?
I would say no. I'd be very surprised. It's possible that you could apply using the same instrument and apply under the Oaths Act or the Powers of Attorney Act here to have the same instrument treated as stuff here, but by default it won't. I did.
Like
It has,
even if he doesn't live in the same country, like even
mm,
if my father doesn't live in
yeah,
Australia, I can still
yeah,
give him power of attorney without. Yeah.
yeah. Cool. Oh, that's really good. Yes, there you go, those things. So you can, um, you would. It's not going to apply to your stuff in Australia, at least not. Look, there may be treaties that might allow for that to happen, but my understanding, the times I've had to use the Powers of Attorney Act in Queensland, uh, I've never seen it happen where you're trying to use one just in case of. Yeah, that's right. Look, it's actually, guys, it is actually a pretty smart thing to do to go through and do that. You've just got to be mindful of remembering to revoke it, because when you go back, and again, we're going to talk about trust a little bit later as well. Everything is all fine and good. Oh, you've got it here as well. Enrico's, you've done the one here as well.
Yeah, I speak anyone. No, the Italian one, I did a total one. In Italy, he can do whatever he wants
Oh, okay,
for
cool.
my goods, company, bank account,
Yep,
everything.
yep. Oh, that's
Here,
good.
that one can be validated. No, it's valid. Can be validated from the court just in case of death.
Ah, okay.
That if I can have like my superannuation, things like that,
Yep,
he has to take it
yep.
in the case of death.
Yeah, nice. Yeah, it's good. And look, it's something that I think the key sort of takeaway of this is that it's actually the aspect of trust that you guys have in your family. And later on tonight, I'm going to be talking about some cases involving a woman called Gina Reinhardt. Does anyone know who Gina Reinhardt is?
Yeah, that one that sued their kids because they were spending too much money.
Yeah, yeah.
She's amazing. She's the best.
She's Australia's wealthiest person. Uh,
$15 billion.
yeah, yeah, yeah. She's a character, but they've got a few cases involved with it because it turns out sometimes families do have big fallings apart, and it doesn't turn out the best. But it's look, it's a helpful thing to do as a strategy to set people up to be universal agents, but provided there's an aspect of trust. Um, all right, so I'm going to move on to the next one, which is dun, dun, dun. All right, some types of authority. Now, these are the agents. Look, it's actually really not that important what we call those things. The authority, though, this slide is important. In fact, if anything, this is all of agency that you really kind of need to know. It goes like this: if Enrico appoints me to go to Ingham and buy a house and spend no more than $200,000, all right, we call that actual express authority. Okay, he is the principal. He is clearly, overtly expressed that I am acting as his agent. And usually you'll do that through a written document, a written instrument. Okay? That's the first thing. Now, in me driving to Ingham, all right, strictly speaking, I only have the ability to go to Ingham and to buy the house. That's the only thing he's appointed me for. That's the actual authority. But in practice, as part of trying to fulfill this particular purpose, all right, um, I'm actually going to have to go through and do some things that are related to that as well, as part of it. So that I'm going to have to go on my way to Ingham, stop and buy petrol, for example. So that's when what we call actual implied authority. All right, those are the those are the that's the core bit at the top where I've actually been empowered to do something, and it's things that are tangential or related to that. Now, the tricky bit is the third type. The third type is this ostensible authority. That's where stuff starts to break down, because ostensible authority is not about the actual relationship between Enrico and myself. It's actually not about that at all. Ostensible authority is a rule that says if a third party, a reasonable third party, is looking in at me, would they think that I was acting as his agent? Okay? And so that it's whether a reasonable person would think when a person rocks up to a particular auction in this case, and I'm wearing, I don't know, Enrico's company logo, and I've got the letterhead, I've got the business cards, I've got my driver's license. Um, It's whether it's reasonable for that third party to actually think that a particular person is acting as an agent of them. Now, and the example that I used to give with my students, which I'll give you again now, is the working in. I used to work at petrol stations as a young guy, washing windows and stuff. And so every so often, I'd be working there in my little Shell station and logo shirt. Every now and then, you get somebody from another Shell station would just come in, and they would just get petrol, and they'd be still wearing their uniform. Okay, and it's always kind of funny when that happens. There's people you don't know at all right, and they're there washing their own windows. Now, what would happen if that person then started washing other people's window, all of our customers' cars and their windows? All right, what do you think would happen there? Hina? They were not at all. I'd never seen them before. But, yep, yeah, and they're just coming in and starting to work. They're just wandering in and starting to work, and they're washing people's windows and collecting money from them. Yeah. What do you think? What do you think should happen there? And assuming we just think this is hilarious, I'm not doing anything about it. I'll tell you what does happen. Ostensible authority happens. If a person pays the money to somebody wandering around a petrol station forecourt wearing the uniform, and there's other people that are in and around that could see this whole thing, if it's a reasonable third person would think that person has authority to act, then um, the entity, in this case the petrol station owners, are going to be bound. So if that person pays the imposter the $20 and then drives off, and the imposter takes the money, puts it in their pocket, and then disappears, that contract is still formed. That is where ostensible authority will apply. It applies in situations where a reasonable third person would think that somebody is acting on behalf. Yeah, you know. Yep. 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 You just say you're not bound. You're not bound. You're a reasonable third person would think, yeah, yeah. That's right. Look, it's trickier. I mean, it's always hard with some of these sort of factual situations to impart them in different sort of contexts. Um, but it actually comes down to in terms of determining whether something's reasonable. It's actually the amount of control that that particular petrol station would have over the area. So if they've just let somebody wander around the forecourt, if I just let somebody just walk around washing windows and do that and making it look like that, or say for example, if somebody walks into McDonald's, I believe they actually have rules about this that you can't walk into McDonald's wearing another McDonald's um, uniform from somewhere else. But in theory, if you walked into there, and you walked into that, people would think that it's reasonable to think that you work there. So, which is what, to flip that around, if you guys have businesses and people come in and they are wearing your uniform or something very similar to your uniform, your alarm bell should be going off. Because if people wander in and start making contracts with those people, you've got a duty to make sure that you've taken reasonable steps to make people aware that they are not your employee. Okay, it happens a lot with things like employees about to leave, or employees that have left and start to do naughty things as a result. Yeah, was that one there? Oh, lovely. Hi. That's right. Definitely wasn't. Yep. That's the point. He wasn't an employee, so he had no actual authority at all to accept the money. He had no actual authority at all. It's whether though a reasonable third person would think that that person has authority. Okay? And there, if a person is walking around a forecourt wearing the Shell station uniform, washing people's windows, you hand them probably these days, $100 note for your petrol. Whether it was reasonable to think that they had authority. And there, it probably would be. However, if instead of a customer coming in, paying $20 to that person. What about if it was the landlord wanders in, sees somebody wandering around washing windows wearing the shell uniform, or any person, um, and wants to get somebody to extend the lease of the petrol station for another 3 years? What do you think about that? Abhishek, you there?
Yes, very much here.
Yeah. What's your thoughts on that? If somebody walked into your business, approached one of the employees wearing like a uniform, and asked them to sign, assuming it's your landlord, and asked them to sign for a 3 year extension, is it reasonable to think that you could use this rule, this ostensible authority? No, of course not. It sounds crazy, but it would work in the first case. The $20 with somebody wearing the uniform would be fine because a reasonable person would think that person probably has authority. It's not reasonable to think that all employees of retail business are going to be empowered to change things involving the leases, long-term, substantial, contractual things. And so that's really that's the key thing. If you guys can really gel this in your head, really that's pretty much it. There's difference between actual express, implied, and ostensible authority. That's really the key thing. Um, and so that's it. All right, I'll move on to the next slide, which is a couple of things here. Agency, you can have through this, again, consensual appointment. So Enrico says to me, go and be my agent. That's consensual appointment. All right. Whereas this, what we call the ostensible authority is created, essentially it's actually in the area known as estoppel. It's not so much that there is any agency relationship. It's just that in the case of the petrol station, they're stopped from denying the existence of this relationship. Why? Because I've let people run around the forecourt wearing a uniform that was similar to the actual ones, collecting people's monies. That's what we call an agency through estoppel. That's the ostensible authority. Agency can also happen where somebody's gone and acted on someone's behalf, and they've acted outside the scope of the agency. Afterwards, you can say, okay, that's fine. So, for example, Enrico has sent me to Ingham to buy the house. Don't spend more than $200,000, and look, the house is there, but the bidding has gone to $220,000. It's too much. All right. So Enrico goes, looks like a really good deal. Maybe I'll bid 230 myself. Okay. So he then bids 230, goes back to me and says, hang on, was it me going there? Maybe it was me going there. I've seen that it was 230,000, and I've gone back to Enrico and said, sorry, mate. The thing went for more than 200,000, but I just bought it myself anyway for 230. And again, Enrico actually has the option here to turn around and say, okay, that's fine. I'll still have that house for 230. He can ratify this, and he can ratify situations where if I was acting within the scope of agency, and I have exceeded that authority, he can go through afterwards and say, that's okay. I'm going to deem you to still be acting as my agent. Just have a little think about that one for a second. Usually, by the way, this doesn't happen when I wander back and tell them about it. Usually people find out later. So it's a much more likely situation where the house sold for got bid up to 220. I bid 230. I've won the house. All right. And then I've then found a buyer for it the next week for $400,000. Because I had gone there within the scope of agency, all right, Enrico actually has the ability to usually you'd ask the court to ratify that particular arrangement, and all of that profit would belong to him. I know, right? It seems a little bit strange, but because I'm acting as an agent, I can't make secret profits as part and parcel of that. Even though, in theory, he couldn't have done or achieved that particular result because he'd only given me authority to act within up to 200,000. It takes a little bit of getting your head around. It comes up a lot in company law, by the way, where directors go off and do things when they find out that a company isn't going to take a particular business opportunity. All right, so oh hey, there's this investment in this new property development. The company directors have all looked at it, determined that it's not for them. So one of the directors then goes off and invests in it herself or himself and makes a large profit. If that person only found out about that particular investment because of the investigation that they did as part of the company director, that the company actually later can ratify that and say, actually, you as a company director were working within the scope of agency, and therefore we're going to say that transaction was done for us. You can actually do that. You can ratify decisions afterwards that have been made, like, yeah, Hina, yep,
Simon, you were saying that suppose there are 5% direction for company, and out of them, one of the director decides to go ahead with one of the investment
yes,
because the others are not going for it. But
yep,
later on, if
yep,
the company sees that he went well, they will say since he was working in the company,
yep,
so this deed is part of the company.
yep, yep, yes, you're right. And you can ratify that decision as part of it.
So, but if he purchases that to make that investment individual basis, still they can claim it.
Yeah, that's why you have to look. You can get around these things with full disclosure. This is the key thing because you have to do it and you're afforded a statutory protection under the corporations legislation, but you are not protected in the rules of common law and equity. Regal, Hastings, and Gulliver is the case involving that, where the company director literally said, hey guys, hey, I know that we're not going to do this investment. I want to do it myself. Is it okay if I do this? I'll put all my cards on the table. I'm going to go through and do this because for whatever reason, the company couldn't get enough finance. I'm going to go through, is that okay? And the directors all said, okay, went off and did it, made a whole bunch of money. Then the company later on said, no, we're ratifying that decision. And this guy lost. All of the profits actually were given back to the company as a result. I think you guys do company law with Louise, I think, for the MBA. I'm not too sure. Law of business organizations or something similar. So that is something just to make note. It comes up more in company law than it does here. Um, Another type of agency is agency of necessity. If your neighbor is away for 6 weeks and a cyclone hits, all right, and their roof is blown off, you, as the neighbor, can actually go and get, pay for money to have the roof repaired. And when that neighbor comes back, assuming you've gone and spent $10,000 and you've sent them the bill, they cannot say, oh, no, I didn't authorize that. No, that's not how a law works. Let's call it an agent of necessity. If you need to spend money to save life and limb or to prevent wasting of property, usually it has to be something big, like it's about to burn down or something similar, and you go and spend money, you can actually ask the court for you to be declared an agent of necessity to make them pay. And look, it doesn't come up very much because usually people mind their own business. But just make note that there is a protection in the law for doing that. And the courts have a pretty dim view on people that weren't willing to pay in those situations. Agency can also be created by operation of law. So things like Powers of Attorney Act, for example, or the public trustee. Okay, next one. Click, 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 click. Nathan.
Hey, I have a question on the necessity.
Yeah.
If I have got a tradie on the field, shall I go and fix it and pay for money? Like if I'm a tradie on the field.
You're a tradie
Yeah. Yeah.
and you're going and working on somebody's house.
Yeah, I mean neighbor
Yeah.
in that situation. Could I able to claim for money for myself?
Uh, Oh, I see what you mean. If you so if I'm a tradie and I go fix my neighbor's roof, yeah, you could. You might have a harder time proving it because it's difficult to quantify. It's difficult with labor when you're doing things that involve labor, cleaning, doing and fixing houses, and repairing things are notoriously difficult to value. It's one of those things that because it comes up a lot. Actually, comes up not just in this particular quite narrow example. It comes up in other areas of law as well. Experts in terms of valuing their own time. Solicitors. We hilariously lawyers, if they self-represent, can still seek costs from the other side. Not because we get some inherent right as lawyers, but because we can substantiate the time, assuming we have to take time off to go and act on our own matter. It's an old rule. I can't do it personally because I only have a volunteer's practicing certificate, so I couldn't even get up on that. Um, Usually, I mean, yes, in theory you could do it, but there'd be substantiation problems if you did go through and do that because you're trying to work out, well, what's the appropriate rate? Because if you think about it, tradies don't usually have an industry-wide sort of set rate for doing certain things. Whereas other professions, accounting and law, for example, you can have fixed scaled costs for things and you get third parties to come through and value it. It's a little bit tricky. Okay. Ending agency relationships. Okay, agency relationships end. Yep.
Can I just one thing because probably I missed we didn't talk about it. Where is the place when I can do when I can make the agency? That's I mean, it has to be a public office,
No,
judge,
no.
lawyer.
It's like a contract. It's a private arrangement. Just usually, like you can do it orally, but usually you do it in writing. You just put it in writing. I appoint you to go and be my agent to go through and do that. Usually, and again, it's on the next slide. It's a contractual relationship. So one person appoints the other, and there's the payment of money to go through and do that. So if I'm going to go buy this house for you, you would pay me a fee of $100 to go through and do that as part of that. So that's those things.
Even for the total, what's the name? Total power of attorney.
Ha! Usually, you only have a full power of attorney when you've got a very, very, very trusted family member. That's not a contract. That's not a contract as part of it. Usually, again, I don't know. You guys remember that intention to create legal relations? It's not going to be a contract there, but it still can be an agency. And powers of attorney must be in writing. That's a statutory requirement as well. Okay. So agencies end if you finish it. So in other words, I go and buy the house. That's done. End through agreement. Again, usually the rules of contract apply. Revoking. So when the principal says I now formally and officially revoke all the powers that I've given to you. Renunciation. That's the same thing, but from the other side, from the agent doesn't want to be bound anymore. Bankruptcy. Insanity is a bit of a nasty way of putting it. Mental infirmity, death will all end agency. Frustration, illegality, and again through operation of law. So if the Powers of Attorney Act, for example, says agency ends at a particular point in time, those things are pretty straightforward. Notice there's no, I haven't put any citations for these. These are just principles for you guys to know off the top of your head. In other words, you don't need to put them in the exam if a question comes up. Duties of principal. Principal, you've got to pay, assuming you've got a contract. Again, family stuff, you wouldn't have to pay. You do have to indemnify them. So again, if I'm driving to Ingham and I crash, by default, you as the principal actually have to indemnify me for the cost of that particular crash. Usually, you want to have some insurance component as part of it. Oh, and also not prevent them from doing it. If you appoint me as an agent and then try and thwart it as well, you have a duty, a fiduciary duty to go through and actually go through and not stop me from fulfilling my particular duty. Their duties of agents, they are fiduciaries, so they have to do things, they got to obey instructions, use due care and skill, do things on your own. If Enrico appoints me to be an agent and it's clear that he's not giving me the ability to what they call to delegate that to another person, I must act personally by default. You can't outsource fiduciary duties. You can't do that. It must be you. Your responsibility lies with the person. An account, this idea of accounting to the principal back for anything that you get as part and parcel of it. Okay, that's all I want to say about agency. Might just take a couple of minutes, probably not too many, because that took a little bit longer than I thought it would. But we're going to go and we're going to talk about trust starting in the next slide, which is the second, was going to be really the second 2/3 of this lecture. So give us a couple of minutes, maybe 4 minutes, and I'll go and have a drink and I'll be back in a minute. Okay, thanks all. All right, let's do this. Trust law. It's a heck of a thing. I am grateful that I learned all of this stuff, but I've only really done it when studying essentially as a lawyer, and then going and doing stuff in law. And I have found that as the times where I've taught business law, both at the undergrad and the postgraduate level, that this is an area that usually people are quite grateful to go through and do, because you don't seem to get it from anywhere else. Actually noticed that the requirements that we have to meet, which is for the Accounting Society mandates that we need to teach you guys this. And I was quite surprised that it didn't really fit anywhere. You do a little bit of it in tax, and you do a little bit of it in the company law subject, but really it should have been taught here. So here goes. First thing that you need to know, the trust is fiduciary. Okay, so similar to an agent and similar to employee-employer, director to company, business partner, solicitor client, and so on. Its trust law is a creature of equity. Okay, and fundamentally, a trust is just the separation of legal title. In other words, the person whose name is on it and the person who has the burdens of looking after it. So separating the legal title and the equitable title. This is the benefit, the good things about owning property. So if we stop and think about that, what are the good things? I'll put this to the class, put it to everybody, throw your mics on. What are some good things about owning property, both real property, so land and buildings and so on like that, as well as items of personal property? What are some good things?
Are you asking to us?
Yeah. What are some good things about owning land? We're thinking particularly land and buildings. What are the benefits of having land and buildings? So what are the good bits? You can what?
Impose tax. Second, tax, because you save money if you everything is in a tax.
Oh, no. Leaving trust aside, we're just thinking just in the general sense, what are good things about owning property? What's a good thing? If you own a house, what are some good things that you get from that? You get it's good asset. Yeah, they appreciate. Okay, so it's an investment. So usually the land appreciates in value. The property, in theory, the asset diminishes over time. But yes, so you've got capital. You've got capital growth. Sure. What else? What are some other advantages of having a house? If you own a house, let's just say, Gaetano, I've now given you a house. There you go. You now have a house in full legal title, legal and equitable title in Douglas. Yeah, assuming that it's your house. What are some good things? What are good things that come from having a property? What are benefits? Yeah, assuming you own a house, you got no mortgage on it, you got no nothing. No, just think about this conceptually. All right, there are good bits. Uh, uh, Abhishek, yeah. What are the good things, Abhishek?
If you have a title clear house, in
Yeah.
need, you can always mortgage it and get more money.
Yes, that's a good one. Okay, it's a good one. A bit more complex, but yes, you can mortgage it. So that's one thing. If you have title to something, one of the good things is you can mortgage it to get more money if you need cash. Sure. You can also rent it out and generate income from it. You can run businesses from it. You can lease it to other people, either through residential or through commercial leases. You can gift it to people. You can subdivide it. You can these are the good things that come with owning property, right? And for those that have owned property, what are some of the bad things?
You are reliable for what happened to them.
Yes. So you have the liability when people come into there if they suffer personal injury or property damage. Yes, you got liability. You've got. I might as well just.
If you have debt, they can take out your house.
If you have what? Sorry.
If you have some debt with third party, they can take your house in order to satisfy.
Yeah, that's true. You can lose it as part and part as possible, but really, the things I'm thinking of here, the negative things about owning a house. If anybody that's owned a house, you have to repair it. You've got to insure it. You've got to pay rates. It's essentially like a local land tax and water and electricity. You've got to clean it. You've got to keep the gardens maintained. You've got to just do a whole host of things. So if we think about that, these two things, the good bits and the bad bits, all right? What a trust does is it separates that. It is the separation of the good bits and the bad bits of owning property. And once you've got that into your head, I know it takes a few goes. Once you've appreciated, that is what a trust is about. A trust is fundamentally about separating the good bits and the bad bits of owning property so that two different persons or groups of persons can get that. An example, I have an express trust, which at the moment only has $10 in it, but eventually, when this particular house I'm in now, which I'm going through a property settlement, when this is completed, that will be moved into my family trust. And my family trust has two beneficiaries. It is the beneficiaries are me, as well as my 9-year-old son. Now, a 9-year-old's very good at managing houses.
No,
No,
but you need a tutor, someone that can do it in order to preserve the value of the house.
that's
But
right. Yes,
because it doesn't have the capacity yet.
yeah, that's right. And so that the idea is that with trusts is that all of the burdens of managing the property are dealt with by the trustee. So the trustee is the person who has legal title. They are the person that has duties. They have all of the bad bits about owning property. The beneficiaries get only the good bits. Okay, that is fundamentally what a trust is about. So here with this particular property, I'm actually the trustee, but assuming that I'd set up a little corporate thing, or I had a friend who was the trustee, it wouldn't really matter. That particular person has to do the insurance. They've got to make sure the place doesn't fall into disrepair. They'd have to go through and ensure that the rates, you said the rates are paid, the insurance paid, the pest control's paid, all of those things. And the thing has been used to generate some income as well, as need be. That is the duties that are placed on a trustee. All right. And the beneficiaries get only good bits. You never place duties on beneficiaries. That's a fundamental rule in trust law. Beneficiaries only get the good bits. Okay. Once we've got that, so I've made the point here in regards to the Income Tax Act. Next year, you guys will do the tax subject, I presume, and so you'll do in week 8 or 9. You'll do the taxation of trusts. You need to know that unlike companies and incorporated societies, trade unions, universities, government departments, unlike those things, trusts are not legal entities. A trust is not a legal entity. A trust does not get sued, does not have standing in the eyes of the law. It's not a legal thing. But we usually treat it as an accounting entity. What does that mean? You can, for all of the assets that I've collectively lumped into my family trust that I've set out in the one instrument, at the end of each financial year, I can do a balance sheet. I can do a profit and loss statement, or we were supposed to change the names when I did accounting. A statement of financial performance and a statement of financial position. I don't know. What are the names at these days? Is it just either or? Don't know. Ravneet? Okay, statement. So it's a statement of financial profit and loss. Okay, income statement. Yeah, sure thing. But the nice thing is, we all know what we're talking about here. And so you can do that for the trust, but at the end of each tax year, you actually have to determine what's going to happen with the income from any given trust. Losses for a trust are kind of useless. In theory, trusts shouldn't even get losses, but they do from time to time. The losses can't be allocated to beneficiaries. Why? Because beneficiaries only get good things. And in theory, a tax loss is a bad thing. I know it sounds a little bit strange, but the accountants and us will be going crazy. You'll also notice that Income Tax Assessment Act is the old act. There's two taxing statutes. There's a 1997 Act and a 1936 Act. They've been trying to move the old one into the new one, and they've been trying since 1997. They've only got about 2/3 of the way through. It takes a very long time. It's actually to do with the Australian Constitution. They can only do one thing at a time. That's why it takes a really long time. It's not just that Australian politicians are lazy. Okay. Also, thing to note is this last point. Trust can be created voluntarily. So I have an express trust where I have my property and I leave it and I separate the burdens. So I have a person appointed as a trustee, and then we have my child as the beneficiary. That's easy. For the purpose of this example, we'll say I'm the trustee and my child's the beneficiary. That's an easy one. That is what's called an express trust. All right. That has been done voluntarily. I voluntarily become a trustee. However, there are some other types that we'll talk about a little bit later in this, where the court has come along and made someone a trustee, usually when they've done something bad, which we'll get to. And so trustees, the law is still the same for both. If you're a voluntary or an involuntary trustee, and equity doesn't let you sidestep anything. If you are made a trustee, you're not going to be able to sidestep it. You can't just resign. That's not how the way this thing works. All right, so we'll start with the first type, express trusts. These are ones that people have voluntarily made up. Okay, so there's three people involved in this. You have what's called the settlor. That is the person giving stuff away. You have a trustee. That is the person that the settlor gives the stuff to. In other words, gives legal title to. And then you have the beneficiaries. You can always have objects, but I'm not getting to that level of complexity here. Just think of beneficiaries here. So it's a three-person system. I'll even draw on my little screen. Blah, blah, blah. Overtly created as my little rectangle. All right. It's created by the settlor. Oh, I didn't put the word beneficiary there, and the trustee voluntarily undertakes it. So for example, my family trust is my friend Rebecca, and and so the way the trust worked was, Rebecca, give me $10, and she went, what? Yeah, you're gonna give me $10. That's how it works. And literally, if you guys are accountants, you will actually be called to do this. I'm not kidding. In Queensland, probably everywhere else in Australia, accountants often are the settlors on trusts. This happens often. And a part of that is the settlor, as that can be the accountant giving a sum of money, $10. All right. What that means is that they're giving away that $10 to the trustee. All right. So the trustee now has legal title over this money, and they're holding it for the benefit of a beneficiary. And so here, for example, say that I appointed Alma to be my my trustee. If I'm the settlor, I give it the $10 to Alma, and they hold it on behalf of someone else. Say QN, for example, could be the beneficiary. That's literally all it is. It doesn't require registration. Okay, that's the first thing you need to know with trust. Trusts don't require registration, and for some things, some classes of assets, it doesn't even need to be in writing for express trust. You can do this orally. Okay, so you can go through and do that. However, if you're talking about real property, land, and a variety of other types of things, it does need to be in writing. All right, so that's an express trust. And again, they come in two flavors. You have what's called a fixed trust. That means that once the property is vested in the hands of the trustee, every year, each of the beneficiaries have a certain percentage that they are entitled to. All right, that's a fixed trust. And usually the instrument, usually a deed, will say, we've got four beneficiaries, Hina, Emmanuel, Kamal, and Karen. Got you four. Let's say you get 25% each. All right, there's no discretion by the trustee. Okay, whereas in a discretionary trust, as you could imagine, the trustees do have discretion. So every year, beneficiaries can ask them for a distribution of income, and they can either pay it or not pay it. It's their discretion. Okay, that's an important, really important point. They have a duty to consider a particular distribution, but they do not have a duty to pay it. And I'll note that discretionary trust, particularly for family arrangements, are very common. That's a common mechanism. Often where the trustee is either a family member, or, usually a senior family member, or it's a corporation specifically set up with the senior family member as the sole director. Okay, that's how that works. So just make note, every year a trust makes income. If it makes a loss, well, too bad. You can't allocate the loss. You can't carry it forward. You can't allocate it to beneficiaries. Uh, Assuming that a trust, which is again is a collection of items of property created in the one instrument, that income is usually given to beneficiaries. In a fixed trust, it must be given, and it must be given in the percentages written out in the instrument. In a discretionary trust, the trustee chooses every given year. It's a very powerful mechanism. Abhishek.
Yeah, Simon, I had in my mind. Say, for example, me and my wife
Yeah.
own a couple of residential and commercial properties.
Sure.
Now, say, for example, if now I form a trust and put all the properties under a trust.
Sure.
That in case of our demise, the properties will go to my kids till the time they become legal.
Yep.
Till they reach 18 years of age, the properties will remain in this trust for their benefit.
Yeah. There's some background noise there, boss. It's really hard to hear. Oh, it's better.
Now it is from my side, yeah. Okay, so I was saying, again it started. It is not from my side, Simon, I'm sorry.
Okay, I'll just turn mine off.
Okay. So, so for example, I was saying, me and my wife co-own a couple of properties which include residential and commercial properties. Now, we decide to form a trust to safeguard our kids' future, children's future, okay? And decide that till the time they turn 18, these properties will be a part of the trust. Post that, they'll be the legal heirs who will take over the properties. Now, in due course, okay, yeah, you're saying something.
Yeah, it usually the way these things are structured is that you set the trust up now, and the kids are beneficiaries the whole way through. Because the problem is, when they reach the age of 18, they can then ask to leave, which can be a problem with some of those things.
Okay. Now, the question that I had in mind was, say for example, a couple of years later, me and my wife decide to separate. In that case, what do we do? What happens to the properties? I mean, do they stay with the trust, or we go into a legal battle and fight it out, slug it out? What I mean?
Okay, so a couple of things. And the case is actually Kennan and Spry in Australia. It's the bottom case there, which I'll just quickly explain the facts of it. Kennan was the trustee, I believe, and Mr. Spry is actually Spry QC, very senior lawyer, and he wrote the textbook Spry on trusts. So this guy knows trust law really well, and he basically set up a family trust so that, and he'd set it up a long time ago, in the 70s. All right, and then by the later on, when him and his wife started to have difficulties, and then they separated, he then did what's called a subtrust, where he took the interest, which was essentially half each between him and his wife, and then moved all of the assets essentially, or the equitable right to those assets, to a subtrust, which had all his 4 adult children in it, who were also independently wealthy. And he wrote the textbook, but this went to the High Court. I'll get to that in a second, Enrico. Went to the High Court, and there, the High Court actually said, no, Mr. Spry, you've got it wrong. And so they had this awful argument where the person, probably the most knowledgeable person in trust law in Australia, and the High Court are actually saying, no, actually, we're the High Court. And so they fundamentally changed trust law and family law in Australia. The case is just, it's crazy. They basically said, for the purposes of the Family Law Act, we're just going to value the half of the discretionary trust, even though it's completely discretionary, and he was the trustee, he could just pick and choose how much to pay any given year. We're going to value it as half each. He has to pay $5 million back. With your example, once you've moved things into trust, the whole point about a set law giving the stuff away is that it is gone. It's moved out of the range of the ability of you to recall it. Now, the mechanics of family law, the Family Law Act, will kick in, and the court does get power to do things. But the equivalent to the family law regime doesn't exist in the subcontinent. It doesn't exist in India to anywhere near the same extent that it does here. But it actually doesn't exist even that much in New Zealand, to be honest. Australia is quite it's quite a long way ahead in terms of the court having a lot of say. As I said, I'm going through a family law matter now, and I've got all my paperwork with me here. This is for an incredibly minor matter. Yeah, lots and lots and lots and lots and lots and lots of paperwork. It consumes a lot of legal time as a result. But the key thing to note there is that when you set it up, leave that on the back of your mind, because if you do separate, in theory, your ex-partner could go and ask for her share to be paid out, which we'll talk to a little bit later on in this lecture. Okay, I'm going to move on though, because all right. Now there's two ways of setting up an there's two ways you can set up a trust. You can either do it while you're alive, or you can do it while you're deceased. No, don't my computer. No, I hope my computer hasn't crashed. Oh no. I'm back. Okay. I'll turn my video off. I just don't know. And the weird thing is, I can see me. It looks like it's frozen, but I can still hear the audio. I'm still streaming. There, either which way. But I'll just explain this part here, which is I'll turn the video off. Which is this idea of having a trusts that are done while you're alive and trusts that come into effect after you die. You can have what are we call testamentary trusts. They are set up by the executor of your will. You map it out in your will that says, after I die, I want stuff to be held in trust and that to be passed on, usually to come into effect when you pass away. That's a testamentary trust. Must be in writing. So testamentary trusts must be in writing, must be mapped out in your will. Express trusts, usually you do put them in writing, and you must do it if you want to have real property. You want to put land or, what have I got? Intellectual property, certain chosen action, equitable interests of future property and things like that. So, but look, to be frank, if you guys need to set up a trust or you're an accountant, you're involved in doing this, always do it in writing. It'd be crazy to do it orally. Okay, these are what's called express trusts. Here, probably just quickly, is the reason for doing these things. Why do we do these things? Well, the things are here. First bit, separate the good bits and the bad bits of owning property. That's the fundamental thing about trust and trust law. So the good bits can be, my 9-year-old gets all the good bits of having property, get all the income streams and the beneficial interest. Eventually, when the trust vests, in other words, when eventually the trust ends, he'll get to own the property on his own. Then it becomes his, both the legal and the equitable title. It's his, the trust ends. Yes, can you please change the ugly little green frog from the picture? Ugly little green frog? Oh, it's the baby Yoda. I'll tell you about that at the end. I've got a silly story. All right. A good advantage, though, is for you guys, helpful piece of tax knowledge is income splitting. So if you have 5, and really it only works for adult children because minors have got strange taxation rules. So let's just say that there's got me and 4 of my siblings, Hina, Salba, Staines, and Vina. All right, and the 5 of us are beneficiaries of a trust, and let's just say that our mum controls the trust. Each year, she could choose to allocate the income to the person with the lowest marginal tax rates. You guys are aware in Australia that they have quite a steep progressive tax system, with the idea being every dollar you earn up to the first $18,200 is tax-free. It's actually 0% taxed. Then you're taxed at a small amount for every dollar you earn. I think 17 cents to the dollar for every dollar above 18,200 up to $37,000 per annum. Then you're taxed at 30% for every dollar beyond that up to about 80,000, 80 or 90,000. Every dollar you earn above $90,000 in a single tax year, you're taxed at 37 cents to the dollar, and every dollar you earn over 180,000 is taxed at 47. I think it's 47 and a half cents to the dollar. All right. So what does that mean? It means that if me and Staines and Vina we've got really, really good jobs, and we're earning over $190,000 each year, it would be crazy to allocate the income to us, because we're going to have to pay 47 and a half cents to the dollar on every dollar we're given by the trust. So you would allocate it, in this case, allocate it to Hina. Maybe she's not work. She's stayed home to look after kids for a year, and so she doesn't have a high taxable income. If that income stream is given through to her, it's at the lowest marginal rate. That's income splitting. It's a helpful mechanism for tax minimization. Express trusts can get some concessions, benefits, and exemptions. Fewer and fewer these days. Succession estate planning. It is an excellent way to set things up while you're alive, so that you don't have to worry about stuff when you die. Particularly if you set things up with a corporate trustee. If you're here with this house, eventually I'll set this up so it has a corporate trustee. If I happen to die suddenly, nothing would happen. The house would just carry on with a corporate trustee. It would just carry on without any difficulties throughout the process of going through, people working out my estates. Asset protection is a very important one, probably the most important one, because, again, going back to my house here, if I put it into a trust structure, and I do this before it looks like dark clouds are on the horizon and my business affairs are going poorly, if I do it a long time ahead of this, and it's validly set up, if I later on my businesses go bad and I go bankrupt, my child will still get to keep the beneficial interest in this house. Okay? It doesn't go into all of the pool of assets available for my creditors to be distributed to them. So it protects your assets from bankruptcy. Okay, so if things go bad in your personal life. Low risk commercial operations, you can run businesses as a trust. I'll talk to that a little bit later. Superannuation is a big one too. In Australia, you can have your own super fund. You can have your DIY super fund where you run your own superannuation fund, and you do that through a very regulated trust. You can also set trust up for charities. Charitable purposes. I'm not doing it for this subject because it doesn't really enter the sphere of business law. It's a big part of trust law when the young fellas do it. They do like 3 weeks. And sustainability. It means things can be ongoing. So, for example, you can have a trust that is there for a particular purpose, to look after a particular tree, for example, or to look after a river. As part and parcel of that. And you can have these things that can last, because the whole point of trust and trust law is to preserve the capital and to get the thing to generate income. By definition, it's a sustainable process, even though it's not particularly high yield. It's not supposed to be anyway. Okay, so that's express trust. You can also have situations where someone's done something bad. All right, someone's done something bad, and the courts can impose, in some situations, a trust, what we call through the operation of law. Now, sometimes these things are created because somebody's done literally something bad. They've breached a fiduciary duty somewhere. They've taken a bribe, or they've knowingly receipted property that's been done that's been tainted by breach of fiduciary duty. And the courts can use trust law as a remedy in that situation, where common law damages is not an adequate remedy. You can also have, all right, these come in 2 flavors, these trusts created through operation of law. The first one is a resulting trust, which happens in one of those 3 situations. This is usually when not so much where somebody's done something naughty, but where a particular usually where something's been mapped out to be paid or money's been held for a particular purpose, and that purpose no longer exists. All right, so that can either be an overt failure of purpose, or where a particular trust was set up to give money or to give capital to someone at a certain point in time, and now it can't. That's a failure to dispose of a surplus beneficial interest. Or in situations where somebody goes to purchase property. All right, that somebody has gone to purchase property. This is a really interesting one. I'll get to in a second. But I'll start with the first one of these three, this failure of purpose. This Barclays Bank and Quistclose was a seminal moment in commercial law in the British legal system. Legal scholars, academics, and judges lost their mind at this because it was a point in time where trust law and commercial trading all of a sudden were combined. So what happened in Barclays Bank and Quistclose? There was a company called Rolls Razor. Okay, Rolls Razor made razor blades, and they had borrowed some money from a lender called Quistclose Investments. All right, and they had borrowed this money specifically for the purpose of paying dividends. I know it seems a little bit strange because now we know in company law you can't usually do this now, but in the time back in the late 1960s you could do this. So they've borrowed the money, and importantly, they have put it in a special account, a specially labeled account with Barclays Bank, and they have told Barclays Bank this money is to be used for the paying of dividends. Right? We're expressly doing it, expressly borrowing it for that very particular purpose. What happened? Well, before the dividends could be paid, Rolls Razor went into liquidation. Okay, it's insolvent, went into liquidation. What does that mean? It meant that the dividends couldn't be paid. Okay, now the question that the court was facing is that, well, this money that they've borrowed, is this money part of the asset pool to be distributed at a certain number of cents to the dollar to all of the creditors? Or is it, and this is the argument that the Quistclose investment guys had, and they won, is it actually to be deemed as being held on trust? And there the court said, and again everybody lost their mind about it, in this situation where it was done for an express purpose and Barclays Bank knew about it, they labeled the account, it was all ready to go for that purpose, and that purpose could not be fulfilled. You can't pay dividends once the company's in liquidation. That's a statutory rule. As a result, the court deemed it to be held in trust, and so all of that money got given back to Quistclose. It did not form part of the assets pool of Rolls Razor. It was a separate item and was not available to all of the other creditors. So from Quistclose's perspective, they got all of their money back. Okay, that was a failure of purpose. And kind of related to that is this, in some ways, is this failure to dispose of a surplus beneficial interest. So in the Re Gillingham Bus Disaster Fund, that was where money was raised for veterans. Sorry, not veterans. No, say that again. Money was raised for people who had suffered a loss of what have you, or had died, I think, or were injured for this particular bus disaster. And so a whole bunch of money got raised, and what they found is that the money, once it was raised, some of it got paid. Then, I think because a couple of the people died, then they couldn't give the money to any other survivors of this particular bus disaster. So as a result, they had to go and ask the court what to do. And there the court said, look, this is a trust that's been set up. It can't, in this situation, you can't dispose of this beneficial interest. The beneficiaries can no longer take this money because we can't identify them in that situation. It's failed, therefore it is what's called a resulting trust. It goes back to settlor. In other words, that money had to be given back. Okay, and the final one, which is block and block. Abhishek.
Can you please explain this bus accident once again?
Okay, so people donated money for a particular a fund that was set aside to help people for a particular bus disaster. A bus had crashed. Okay, and that money was given for the survivors of that bus crash. Okay, now once all of the people in that bus crash had died, all right, and money was still coming into this fund, you're faced with this problem. What do we do with this money? And the courts, again, there is some doctrines you can use to apply it to a similar purpose these days, but the courts didn't use that for reasons I can't remember involving this case. And they said that here, the court said that, look, here we have beneficiaries of this trust we can no longer locate, or they no longer exist. Therefore, that money is going to be set in trust, and it will result back to the settlor. And the settlor in that case were the people that donated money to it. So they could go through as best they can, identify those people, and give them their money back. That was how that mapped out. And another time this can come up, and this may come up in your guys' lives, maybe, is the case of block and block. And if you look at the data on this, is actually a family law case, but it's actually been dealt with in equity, not under the family law regime, for a variety of reasons. One is that the family law regime hadn't developed enough to be able to handle this at the time. And so it's where block and block involved a parents and a son, where they had lent money to the son for him to purchase a property. Okay, so they lent money to the son. I think they lent him a third the value of the property, and he had paid 2/3. But the property was only in his name. And then later on, he sold the property, and the parents, and again I presume they'd had a falling out, asked for a third of the proceeds of that particular, I think it was a block of flats. Block of flats. And the son said no, so they went to court. And in that situation, the parents won. They were able to say is that, look, in this situation where a person puts up money, purchase money for real property, by default, the law does not deem that you are giving it away. By default, it is held on trust, essentially. So the house that I'm sitting in right now, I paid, get those numbers right, I think 48.9% of the purchase monies for this particular property. All right, we paid cash, and me and my ex-partner and her mum put in a little bit of money as well. That's why it wasn't exactly 50-50. And one of the things about that is that if the property goes up in value, you get your percentage about it. One of the curious things about it, though, about trust law, and you're going to love this quirk, if the property goes down in value, and it has, I can actually ask in the general law for the exact amount of money that I put in. You can't lose in trust law. I'd just wrap your head around that for a little bit. So I put in, we'll say half the value of this house, we'll say $155,000 for a $310,000 house. The property's now worth maybe, the value is coming tomorrow afternoon, but it's probably worth about $260,000. Under the general law, I could either ask for the fraction that I put in, which is it was actually slightly less than 50, 48 point something, or the exact amount that I paid. If I can argue and I succeed that this was a purchase monies trust, in other words, that I'd put money up for the purchase of this property and the particular purpose that we've done, which was the two of us to live in, failed, I can ask for that to be returned to me, or rather, the court will place a trust across the property, a resulting trust. Yeah.
Yeah, it's the nominal amount of the money plus the inflation.
Not inflation, the increase in value of the asset. It's the fraction. The fraction will stay the same. So,
Ah, okay,
yeah,
perfect.
yeah. So if the house doubled in value, I'd get double the amount. It's not indexed. Okay, right. Next one. Okay, resulting trust. Now, the next type of involuntary trust, or the other type, is called a constructive trust. These are used as a remedy by the court where they need to resolve things in a certain way. Now, the first type we call institutional constructive trusts. They are used where there's some sort of breach of duty. All right, that usually that they've there's been they can use them for estoppel, they can use them for duress. I'll get to that in the next slide. Um, but the concept of a remedial constructive trust is a very new phenomenon in trust law. It's a relatively rare thing, but it does get used in some situations. And I'm going to see if I can show you guys some examples of this in the next few slides. Hopefully. Yes, I do. Very next slide. Excellent. Okay, so the first time is the kind of the easier ones to understand. That's where somebody has made just done straight up done a breach of fiduciary duty. They've breach of trust, breach of confidence. They've committed what we call equitable fraud, undue influence, unconscionable conducts. With these again is a general law remedy or duress. And look, the courts have always been able to impose these for a long time, and basically to ensure that justice is done. This is a high level policy instrument. Now, Attorney General of Hong Kong and Reed is an interesting case because it's a Privy Council case, all right. And what had happened was that there was a Crown prosecutor in Hong Kong, and he, I think Mr. Reed, had accepted bribes on behalf of the mob to lose cases. Okay, so he accepted all of these bribes. Now, this is where things get interesting. He he went and took the money from these bribes and he invested it in residential property in New Zealand. Now, Kiwis are a bit dumb. We're a bit dumb like that. New Zealand doesn't have any capital gains tax. It is the stupidest, most outrageously dumb piece of social policy planning, tax planning. It made me very sad last year when Jacinta Ardern had to go and front up to the media because she got bullied by a whole bunch of other MPs. Yeah, there's no CGT. It's insane. It is absolutely insane. New Zealand these days has essentially like the feudal system. You either own property and you are literally millionaires, or you don't own property and you live with your parents. It's awful. Anyway, so New Zealand has no capital gains tax, so that this guy he went and bought 6 properties in New Zealand and they ballooned in value, so they like tripled in value. Now the trouble was, in theory, with these sorts of situations, the way the law stood at the time, and you think about this, the money from the bribes was used to it, so that if the court was going to impose something, all right, to give the money back to the person, all right, to think about this for a second, who was the person who fronted up the money? So who paid the money to Mr. Reed? Well, it was the Hong Kong mafia. It was the people who paid the bribes. They paid the money to him. Is it appropriate to give those people back their money? No, it'd be insane. It'd be absolutely crazy to go through and do that. So we've got a bit of a problem here because, in theory, what is the appropriate remedy? If you guys were the judge, I'm really interested to hear what you're going to say here. So just assuming the guy has taken, I can't remember the exact dollars, but we'll assume that he's taken, say, $200,000 worth in bribes, and now there's $2 million worth of property in Auckland. What would you do if you were the judge?
Give the money to the government, the one that he has taken away.
Hmm,
Right.
that's right. But it's an interesting thing because it's not The government's bringing the action, but they're not the one trying to recover the money. And Hong Kong and AG of Hong Kong and Reed is interesting because it's one of the very few times they had to use the doctrine of unjust enrichment, because it's not about creating a trust to, strictly speaking, to compensate someone. It's not what this is at all. And it's really, and again, the Australian courts, when interpreting this case, they would have phrased it in quite a different way. What they would have said is that it was unconscionable of Reed to keep that money. But unfortunately, the Privy Council used this doctrine of unjust enrichment, which isn't really how the things fly here. But it's an interesting point because you need to use equity to fill in remedy defects in the common law. Because if there was a rule, like statutory rule, that was set up for that, and there was a loophole in it, in theory, that guy would get to keep all of the money, which seems inherently wrong for us. And equity doesn't allow for that in these sort of situations. And so they tried. Certainly, the guy had lots of barristers to try and argue it, but he did lose in the end. No, Barnes and Addy, and then later this Australian case of Farah Constructions, when you knowingly either receive property that has come from a breach of fiduciary duty, or you knowingly assist in a breach of fiduciary duty. And again, breach of trust, breach of confidence, equitable fraud, undue influence, unconscious. So if you help somebody do these things, all right, and you receive property from it, the court can impose a trust upon that. All that does, when I say it imposes a trust, it says, look, you have legal title over this thing that you shouldn't. We're not going to take it off you. We're just going to make you a trustee of it. And as we'll see, the duties of trustee are very, very onerous. All right, so that's an institutional construct trust. Yeah, Hina.
Sorry, I missed what happened in the end.
In Attorney General of Hong Kong and Reed, they declared an institutional constructive trust across all of the properties. And so that it meant that all of the increase in value in those properties was not kept by the person. It was you're right. Essentially, the beneficiary was going to be the Attorney General of Hong Kong. So the Hong Kong government is where that benefit ended up going to. Okay. This remedial constructive trust, I'm actually going to give an example, and this comes from Svetnam and Wild. It's actually a pretty neat case. I did to do this for research in terms of elder abuse in Queensland. It goes like this. Very, very common situation, guys. And for those, again, Abhishek, we're talking about this in terms of children, setting things up, and the difference in culture you might find as well in Australia and Queensland and New South Wales in particular. It goes like this. There was an old guy who had a property. This is a pretty common thing. Older people might have real property, land, houses in suburbs that are expensive, and they've got no mortgage, right? So they're pensioners, they're older people. And so it's quite common for them to say, look, if I'll sell my property here and we'll go and live in, Western Sydney, buy a much bigger house, I'll live in the house, put the house in your name, so saying to the kids, put the house in your name, I'll front up the cash, or a big chunk of the cash, and I'll live in the granny flat until I die. And when I die, the house is in your name anyway, so there won't be any problems. Okay? What do you think happens next? Any thoughts? Any potential problems that might come from that plan? It's a common thing, by the way. There's a whole series of cases. Well, what happens is this scheme works fine for about 2 years or a year, or sometimes not even that, sometimes a few months. And then often, by the way, it's not so much the son or the daughter that has the trouble. Usually it's their partner has a falling out with the old person and kicks them out. Because they can do that because they have legal title across the property. And so they then evict the old person. Because remember, this is not a contract. This is just an arrangement between family members. And what the courts say is that in that situation, we will use this because it's unconscionable of the young people in that situation to deny a remedy. And Svetnam Wild was exactly that. An older guy sold his house, went to live with his daughter, had a falling out with the daughter, got kicked out. He had to go and live in a retirement home. And the really, really sad thing was the Queensland Court of oh, is that common? Is it okay? Oh, that's a bit sad. Um, the sad thing was in this particular case is that when it went to the Queensland Court of Appeal, he won. He won comfortably. In fact, he said that look, the guy stumped up. I can't remember the fraction. I think it was about a third of the property. Like $250,000. Stumped. And they said, look, we would have given the house has gone up in value by 50%, or yeah, some amount. We would have given you an amount equal to the amount that you paid plus 50% because it's gone up in value if you'd asked for it. But the old guy didn't ask for it. He didn't need to. It was his own child that he was having to sue. And at the end of the day, when he was going to die, the money was going to go to the child anyway. This is the really, really sad thing about some of these situations. And this went all the way to the Queensland Court of Appeal. The guy didn't ask for a penny more than the exact nominal amount that he put in, even though the court said, look, if you'd asked for it, we would happily have given it to you. But, you didn't ask for it. We're not going to ask why, even though we probably know. But you are undoubtedly entitled to the $250,000 that you put in. And here you go. Here's an order for that. Okay, yeah, some of these things, they can be really, really sad. They're really, really sad cases. Blomgartner's case. These are known, by the way, as Blomgartner trusts. The Blomgartner case, which I'm not going to go into the facts now. But they're basically a flexible mechanism for the courts to impose a remedy where something like that's happened. Something like the case of Svetnam and Wild, where you've got the situation where one person is really unconscionably asserting that they have full ownership of something, even though another person, had either there was some sort of scheme that they had together or arrangement, and it would be really unfair to deny them rights as a result. It'd be very, very unfair. So certainly with this house here, even though I paid for 48.9% of the house, so remember I had this argument. I think you guys laughed at me, Enrico. I think you laughed at me earlier on. Remember how I said how I wasn't worried putting the house only in my now ex-partner's name? The reason for that is I know how trust law works. And I know, as it happened, if I was suing in the general law, this house actually did go down in value. And so if I was to bring an action, if the other side decided to try and evict me, because I'm currently residing here, that I could bring an action in the general law. And if I bring an action in the general law, I will get the exact amount that I put in for this house. And so that my ex-partner would suffer quite a large loss as a result. Does that make sense? I mean, it's not me trying to be terrible. It's trying to cover all bases. But that's literally how this area of law applies. Okay, and so the net result is you guys might think I'm a terrible human being. That's okay. You wouldn't be the first. Oh, bonus points to you, Hannah. Okay, so all right, so we're here. We've got we're talking about creating a trust, and again, you guys may get involved with this. This may think there's something that you guys are ready to go and do, and so just make note that you have to. The settlor has to put the property outside of their ability to recall it. Very, very important. The settlor can't go back on it and take the stuff back again. That's a revocable trust. That will get you into a lot of dramas, actually in tax law more than anything else. So in theory, you probably could do it. You could put a thing in your deed, but you'd be crazy to do that. You're going to create all sorts of dramas with it. And so just know the word inter vivos means a living trust, or so while the settlor is alive, and the executor constitutes, in other words, creates trust when the person's died. It created it in a will. Okay, I'm not going to dwell on that. But some important topics we're studying. Yes, I'm actually going to assess this. So this is going to be assessed, these slides here. And importantly, I cannot stress this enough to you guys, you will not be required for the trust stuff to go beyond the slides. So if you just listen to this recording and you have the slides with you, this will be the material that you can base it on, because it's a very, very large area of law, and I want you guys to have a functional understanding of these things. It's really being able to understand from it. Basically, think about how an accountant would do it. I think that's a fair a fair way of going through and doing it. This is the stuff I wish I was taught when I did accounting. And it is actually required, I've got to point out, by the Accounting Society. You are supposed to know this stuff. Okay, so in practical terms, $10. Okay, so if you're an accountant and somebody says, oh, can you set up a trust? Now, yes, you strictly speaking have to reach into your own wallet, get a $10 note of your own money, give it to somebody, usually put it in an envelope, give it to them, paperclip it to the trustee that you get them to sign. You usually get a justice of the peace to sign as well. You no longer own that money. That is a trust that is created. So my trust at the moment has $10 in it. Literally, it's only $10. I haven't moved that house into it because it's taken 18 months. Okay, and it's very important, again, for tax purposes, that it is not a beneficiary and not a trustee to do that initial step. Okay, there's a really outrageously dumb tax case that you guys might do. I'm not going to go through it now, but it's a very, very dumb. If you do ask me, or well, when you guys are studying tax law next year, if you guys use my slides, because I have published to YouTube a whole bunch of slides for that, you'll see me talk about it. So you can feel free to refer to it there. It's very, very dumb. Anyway, so the main way to do this is to create the trust with $10. Get it all stamped, get it all signed, register it. And in fact, I don't have it here. It's a bit of a shame. You can also, by the way, and mortgage brokers insist on this, once you've got the deed, you've got the $10, you've had it signed, stamped by a JP, Justice of the Peace, and Notary Public, essentially, as they're called in other places. They're called a Justice of Peace in Queensland. Once that is done, you can then send a copy of that to the Department of State Revenue, and they will assess it for duty. They will assess it for $10, which means you have to pay a nominal amount, like $30, a stamp fee for them to stamp it. What that means is that your trust deed now has a stamp from the Department of State Revenue. It has it's been JP'd, so it's had a stamp from a Justice of the Peace. If you go to the ATO site, you can get a tax file number for it as well, even though they're not separate legal entities. They are still accounting entities, and you have a separate TFN, a tax file number that goes with it as well. Okay, those are the practical steps that you go through to create a trust. I have a copy of a trust deed. If anybody needs to do this, I'll just ask me, and I'll just email you a copy of my trust deed. They don't usually, because accountants usually charge quite a lot of money for doing this, like thousands of dollars. The $10 that you have to do literally has to come from you. It actually genuinely does have to be your money that you're giving away. But that doesn't usually matter because you're usually being paid $3,000 to do the setting up. So it's not $3,000 a stretch, maybe $700 to do the whole thing. Okay, does that kind of make sense? Because this is a service that you guys, if you wanted to, you can start doing now. But people do go to accountants to have these things set up. All right, and it's often done by accountants more than lawyers. Okay. Oh wow, sweet, $1,000. I'll happily set you up. I'll set you up a trust for half of that. Trust. What is that word? Go and find that word. Translate that word somewhere. Okay. All right. So that's how they're created. How do they end? Okay. The rule in Saunders and Vautier. This case is just literally, this rule is known as the rule in Saunders and Vautier. It goes like this. Okay, the accountant will charge you more. Yeah, they will. They'll charge you lots. If you are sui juris, in other words, you're not under a legal disability, you're standing in the eyes of the law, and you are the only beneficiary, you're not bankrupt, and you're not mentally unwell, and you're over the age of 18, you can ask for the trust to be ended and all of the capital and income from the current year to be given to you. All right, I'll say that again. If you are the only beneficiary and you're an adult, you're not bankrupt, you're not mentally unwell, you can ask for the trust to end. Okay? That's a super, 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 super important rule that people don't seem to understand or accept. That if you are the only beneficiary, that is just the law of the land. Why? Because you're the beneficiary. There can be some difficulties if the trust instrument says it won't vest until a certain time. All right, because in theory, that's the settlor's intention, but you can actually still apply to the court and ask for usually for guidance on that. By default, you can end a trust. Okay, that's the rule in Saunders and Vautier. And if there are more than one beneficiary and all of them have agreed that they wish to end the trust, so all of them are sui juris, all of them are not in legal disability, all of them want to end the trust, they can jointly do that and get the outstanding income and terminate the trust as well. All right, so that's something that's how you can end a trust as a beneficiary. And you can, even as one beneficiary, end a trust. All right, but there's some gotchas here. You can't just do it as of right. You have to actually so the first little bit's going to read the same. One beneficiary has a fixed share. In other words, you have to work out that you have a fixed share of the capital. So again, that's either it's a fixed trust, or you can make an argument, again, usually to the court, that your amount ought to be a fixed share. And you have to demonstrate that you taking your share is not going to in any way, shape, or form prejudice the interests of the others. What does that mean? If, for example, there was a trust that's set up and the only trust asset is a fund with cash sitting in a bank of $300,000, the three beneficiaries are Franceline, Gaetano, and George, and Gaetano says, I wish to have my share. That's easy. You can just say, I would like my share. I don't want to be in this trust anymore. That is what we call fungible. In other words, can be divided without any difficulty. And you can do it without prejudicing the others. All right. The others, if assuming that it's just a bog standard bank account, it's not going to impact the others at all. All right. However, it's a pretty low bar for the trustee to say, actually, it does impact the others. For example, if instead, rather than being in a bank account, it was in, say, bonds, 90-day. Oh, that's not a good example. No, maybe better. Maybe you've gone and bought shares in a property investment group that weren't going to mature for a long time. For example, you couldn't, and you can't redeem them. Non-redeemable shares that you can't be redeemed for a few years. Usually, you can pay a penalty if you want to partially redeem them. In that situation, that might prejudice the others. Certainly, if it was a house. So, if the three of you guys, instead of it being $300,000 cash, was a house, you can't divide the house. You convert it to tenants in common, but that has other problematic things because that will prejudice the rights of the others because now they're a co-owner with a third party if you go and sell that to someone else. So that all of those things you can argue that's prejudicial. And so that it's only if it can be chopped up that a person can do it and invoke that rule in Saunders and Vautier. Does that kind of make sense? Because look, these are actually pretty important rules because people will come to you. I'm a beneficiary. What kind of income? Okay, so income is different here. It's all income from property. There can be income from a business as well, which we'll get to in a second, but you won't have income from personal services. So usually it'll be the form of rent payments, it'll be in the form of interest and dividends, and it can be in the form of distributions from businesses that the trust has run as well. Prejudicing is not clear. No, I might just explain that again. Look, it goes like this. If there's just the one of you, just one beneficiary, Hina, do you want me to explain that again? Well, the third one basically says, look, if there's one person, rule in Saunders and Vautier, it's easy. If there's two or more people and they all want to do it at the same time, easy. If there is more than one person and only one of them wants to end it, which means the others don't, or the others can't end it because they're still minors or they're under a legal disability, they can only end it by right if they can do so without impacting the rights of the other beneficiaries. So, if, for example, there are 3 beneficiaries, 2 of them are minors, 1 of them is an adult, the adult can end it if and only if they can do so without impacting the rights of the other person. Now, that's a real problem if it's a house, because you'd have to convert that beneficial interest into tenancies in common. That changes the rights of the other beneficiaries because they now co-owners, presumably with a third party if you go and sell it to someone else potentially, which potentially you should do. That prejudices their rights. It's going to have potentially negative economic impact on them, on the other people. And it's a pretty low bar for them to say that. It's very easy with money and with shares because you can just sell a third of the shares, sell a third of, distribute a third of the cash um, as part and parcel of that. But it's tricky when it's got other, particularly real property. That's where things are problematic. Okay, that's how things end. All right, now I'm going to look at trustees, because again, you guys as accountants, you may end up being trustees as well and actually going through and doing these things. And like I said, I wish somebody taught me this. All right, so a couple of things here. First of all, trustees have powers to do things. This is a combination of rules in equity as well as in the Trust Act. And very unfortunately, the Trust Acts are not uniform across all jurisdictions. Very, very, very unfortunately. So occasionally, I'll pop up with something that is actually only in Queensland or applies in some states and not other states. It's kind of annoying that. Trust law is state law. It's not federal at all. Okay, so first thing to note, trustees, you can hire accountants. You get people to do the books. All right, and you have a statutory right to pay those people out of trust funds. Because usually what happens, guys, yeah, sure, I'll move this house, for example, into a trust. Right, sure, that's fine. But also with that, you'll have a packet of money as well that you move into the thing at the same time. And the way it works is that in your bank accounts, so if you guys have Australian bank accounts and you do your internet banking, you go through and you look at your various accounts, ones that are set up as trustees, all right, so if I'm holding things as a trustee, it'll just say, Simon Walker as trustee for the Walker Family Trust, for example. That's usually how it's written. So while strictly speaking, it's me, I hold legal title, it's me, those assets aren't my assets. So I have full legal title over it. I am the trustee. I will do things, but I only get the burdens of doing it. Nathan, yeah.
If I'm having access to the company's bank account, does it mean I'm a kind of trustee for them?
I couldn't quite catch that. So you've got access to bank accounts, the trustee bank accounts.
Yeah.
Yeah. What was the last bit?
So does it mean I'm kind of a trustee for them, or
If you have access to a company's bank accounts, if you have access to a company bank accounts,
yeah?
well, it depends what your capacity is. Are you a director of the company or are you an employee?
I'm a financial administrator.
Okay. No, you're actually an agent in that situation. So that if you are employed by the company, you're an employee. If you are a financial administrator through contract, in other words, that you've got a contractual arrangement with the company to look after and administer the things. If you're not, strictly speaking, an employee, you're an agent of the company. You still have fiduciary duties, but it's not a trust relationship. So it's the rules we had with agency. You're still going to have fiduciary duty. If you go, you steal the money. Sorry, Nathan, give you a bit of a bad rap. If you go and you take the money, you're still going to be subject to the same fiduciary rules and the fiduciary breaches. So if you invest it in real estate in Auckland and it doubles in value, you're not going to get to keep any fraction of that if it's done in a breach of fiduciary duty. You don't keep any of it. So those things will apply, but it's not a trust as such. Different type of relationship. Okay, what else can trustees do? So they can appoint accountants and they can be reimbursed, which is nice. Trustees can borrow money only if the instrument, by instrument I mean either the will for a testamentary trust or the deed if it's a living trust, an inter vivos trust. It has to specifically allow for that. Has the power to dispense income, the maintenance benefits, vast beneficiaries. Okay, so the trustees, both in the general law and in the Trust Act, are given power to not just to give income at the end of each tax year, they can also spend money, given a statutory power to do this, to put towards beneficiaries for things like their education. Particularly for minors, for example. So my child, if I set this up, family trust up, I will be able to, as trustee, to put money towards my child as income as part of that. All right, so that can go and be dispensed to him as part of that process. Okay, so that's something that powers are the trustees are allowed to do. Remember, I said that trustees it's largely about duties, but they have to have powers to actually go through and fulfill some things. Now, this is an important one here. Running a business. Now, trusts can be run as a business, but it's really important to know if it doesn't say so in the instrument, in the deed, or in the will, you're actually only allowed to run a business for 2 years. Okay, so just have a think about that for a second. If the trustee is silent about duration, you've got 2 years. The only reason you're allowed 2 years is usually to wind up the business affairs. All right, so that trusts, while they can be put in businesses, often aren't. There's a few reasons for that. The main one is that trustees are not allowed to make normal entrepreneurial business decisions. Trustees have to act very prudently. It's all about low risk, low return stuff. So if you're a trustee, it is quite different from being a company director. Trustees must take low risk, low return investments. So that if we think about the oh, I love this part, doing my little diagrams. Oh, I love this bit. So if we think about this, oh, we're going to do it over here. Rip and blip. You guys are aware. Okay, accountants, we know how risk and return works. The idea is the higher the risk, bloop, on this axis, bloop, more risk. Riskier investments need to have riskier return. All right? Makes sense, right? That's pretty logical to all of us. I should label the axes. Come on, Simon. It's got to be return, or the demanded return. Demand return, risk. All right. So we know that on these little graphs, you can see that, all right? Hopefully you can. All right. We know that you don't want to have something which is down here. Yeah, that this is bad. This is very, very bad. This is where you never want to be. High risk, low return. We want to find things up here. We also call them unicorns because everybody wants that. Everybody wants to have that. But I mean, good on you if that happens, but that doesn't really happen. The thing is with company directors is that they can do things here, they can do things here, and they can do things here. Their duties are to take ordinary business risks as part of that. So company directors can do that. Trustees, though, are limited to just doing the stuff down here. They're not allowed to take higher risk, even where it looks like it might be up here. They're still not allowed to. You're just not allowed to do that. That's the duty that you have. Okay, all right. So going to that, the trustees do have power to have business. Just note this one down here. Court can grant extensions to this time. So the court, if you have a business as a trust and they haven't put it inside the instrument, because you'd just be crazy not to, and you guys as accountants, that's the first thing you go through and look at. Do they have a power to run a business? And most, like if you had a trustee, most of them that have been mapped out are going to have that, because it's it's pretty crazy for that not to come up. All right. What else do trustees have? Oh, trustees get some rights. Good golly. After 2 years to start another? No, well, you can't. You have to vest it. No, they have to stop it. And then they're acting ultra various, in which case the trustees can be held personally liable if they carry on running a business after the 2-year period. And that's what happened in vacuum oil. That case was on the previous slide. All right. If you properly and reasonably incur expenses being a trustee, you can seek reimbursement under Section 72 of the Trust Act. So if I am the trustee and I have the bank account, which is set up in my name. Again, it's a little bank account, and I have to go to Bunnings and spend money to buy some paint for this house, and I go and spend $500 on paint, and I've paid for it in cash, I can seek reimbursement for that $500 from the trust fund. It's properly and reasonably incurred. Okay, what other rights do trustees have? Trustees have a right, you can have a maximum of 4 trustees in an express trust in Queensland. They make decisions unanimously, and so that, again, must be unanimous, otherwise the decision won't happen. And if one of them breaches, the others are all jointly liable as well. So it's a bit like business partners. However, if one of them breaches and costs $100,000, and so the other 3 have to cough up $25,000 each because the person had no money and they're all being sued jointly. Remember, if people have a joint duty to repay you as the beneficiary, say again, one of them's stolen $100,000 and now they've only got $25,000 left, you can go and sue any or all of those trustees. So say one of them had $100,000, you can just sue them. All right. So assuming that happened, where one of the trustees has spent all the money, one of the trustees had a whole bunch of money, the beneficiary sued them, taken all that money, so that the equity can step in what's called the doctrine of contribution and get the others to pay those amounts. So you can seek contribution amounts from other people. An area of law that doesn't come up much. Okay, when a trustee commits breach upon request, if a beneficiary asks you to commit a breach of fiduciary duty, they can be held. It's one of the very, very few times the beneficiaries can lose out. They have to assist with that breach. All right, they have to go and ask a trustee to commit a breach of fiduciary duty, accept a bribe, or make a secret profit. Their interest can be, we use the phrase we use, is impounded. In other words, that beneficiary can't ask for their interest until the other interest of the other beneficiaries is restored. Okay, trustees can only be reimbursed if either the instrument provides for it or all beneficiaries agree. Okay, really important for those that are accountants are going to be trustees. This is a super, super duper important rule. Okay, by default, as a trustee, you do it ex gratia. Ex meaning without, and gratia meaning a reward. You do it for nothing. Wow, it sucks being a trustee. You guys you won't want to do this now. However, most trust deeds and most will trusts, no way, sad. Well, that's why certainly involuntary trusts are set up like that, because a person's been naughty, and so the courts have made them become a trustee. That's why they're certainly not going to get reimbursement. So here, express trust, you can set up in the deed that says the trustee can be reimbursed. Okay, and look, with a discretionary family trust, remember that the family trust here, I am the trustee. So my deed says, the Walker Family Trust deed says the trustee can be reimbursed and the trustee can be paid a nominal fee for services, an amount for doing it. So I could pay myself to do that without any drama. Okay. What else is there? All beneficiaries of the court orders this. Okay, so the trustee can be paid or reimbursed if all beneficiaries agree to it, which is tricky if they're minors. Tricky because that agreement may not be valid. But finally, the court can give you the power to do that as well. So at the end of the day, you can just go and ask the court to go through and do that. And they're reasonably flexible on that because, but usually professional trustees have things set up in the instrument to start with. Yeah, Hina.
So you mean to say that the trustee cannot say that he has to be paid? It's only possible if the court says that, or
Nope. The instrument. The key thing is the instrument. Does the deed or the will say the trustee can be paid? Usually you would do that.
It will be written by the trustee, right?
Sorry?
Who writes the will and
Who writes a will? The person, you or me or whoever. We can all write wills. We all write wills.
I can write it
Yeah.
myself.
Yes. So you can write a will. In your will, you can say, when I die, the executor is to set up a trust for the benefit of my infant children, for example, if you've got little kids. And so what that means is that you can Now, put in your will that a trust will come into existence after you die, because our kids can't manage stuff. And my child's 9 years old. He wouldn't know how to run a house. God, I've seen his bedroom. It's terrible. Um, so as a result, you can do that. And the law for a long time has allowed you to have what they're called testamentary trusts. They come into an existence after you die, when all of your legal property is vested in, title is vested in a person called the executor. And the executor has a job to distribute the property to all of the beneficiaries, where they're, again, following your intentions. But if some of your intentions was for some or all of that property to be moved into trust, the executive's job is to what they call constitute that trust. In other words, move the legal title from the name of the executor into the name of the trustees for them to carry on and run that trust following the testator's wishes. So that's what you can do. So, I mean, for example, again, if you've got, Henny, you've got little kids, haven't you? You've got 2 kids. That's one there. And so are they over the age of 18 or under the age of 18?
No, my little one is 4 years old.
4. Okay. Oh, good job. Okay. So you've got littlies. So,
Not that old family.
okay. Sorry. I don't know. I've never, I've I literally had somebody in the previous class, Carrie. Oh, you guys know Carrie because she teaches accounting. Well, maybe not. I'm not sure. And she was in my class today, and she's like, Simon, I'm older than you. I'm like, no, you're not. And she said she's a grandmother. She's got 3 grandkids. I'm like, oh, okay, maybe you are. Probably. I mean, I'm in my, I turned 40 something this month. 40, I can't remember, 43. Okay, so but either way, our children can't do stuff. So if we died tomorrow, all of our property, we still want to give it to them, but they're not going to be able to manage it. So we can put in our will, we appoint a person to be a trustee of the stuff, or you could create the trust now while you're still alive. Okay, duties. Trustees have duties. They don't have a lot of good bits. They've got a lot of duties. And duties go like this. They have to, following that little diagram I did before, they have to invest in low risk, can be low return, but they must maintain the value of the particular asset. That's all they have to do. And they have to, you've got a duty to review it every year. That is a statutory duty that you have. You must review them, and you must provide accounts when requested. That's on request. It's actually on request by beneficiaries. Hancock and Reinhardt is the case I was telling you about. This is good old Gina Reinhardt. This case carried on. Oh, that's the Supreme Court New South Wales case, but actually I think it carried on in the High Court. So in that situation, Gina didn't want to give the accounts up, and so they had to go to court to ask for the accounts, and so she had to offer those up because she was the trustee. Gina was the trustee, and yeah, that was so that you must do that. It's just a duty you have. If you don't do it, the beneficiaries can ask for you to be removed. This is the real problem that Gina Reinhardt had because she had $7 billion in her trust. Okay, and she was the trustee, which means she has, and that was discretionary trust, so she could do what she liked essentially with it, because she was holding it for the benefit of her kids. But turns out her kids were little so-and-sos, because it's funny when you have a falling out with your kids. Which case? This is Hancock and Reinhardt. That Hancock in the case is John Hancock, which is Gina Reinhardt's son, and who changed his name back to his father's name, even though it was Reinhardt, I think. So he changed his name back because he really didn't like his mum. And Reinhardt is Gina Reinhardt. She said Australia's wealthiest person. So you just make note, if you don't provide accounts, that is grounds for the court to remove you, have you replaced with someone else. In other words, someone else to take control. So my darling ex-wife has put a whole bunch of things in trust. And she's many, many, many times wealthier, like 20 or 30 times wealthier than me. And she put a whole bunch of things in trust. And I've got to say that, you don't do things like this lightly, because it's all fun and games and it's all fine and good when everybody likes each other and everybody gets along. When your kids grow up, if they don't like you, they can cause, wreak all sorts of havoc when they just work out that they, as beneficiaries, can ask and demand for their share, then your whole family falls apart as a result. It can be pretty awful. And again, the Reinhardt case is pretty awful. If you do want to go and just do any reading on that. Okay, what else do trustees have to do? They have to do things on their own. In the general law, you can't delegate. It's a personal duty. You as trustee must do it yourself. However, if you're sick and you're out of the state, in other words, you're out of Queensland for a year, you can delegate to another person, so the trustee can delegate. Oddly, I don't know why, the Queensland Act actually says that you can't override that rule in the instrument. So the deed can't say trustees can't delegate if they're sick. You can't put that in a deed in Queensland. I don't know why. I don't know why they have that, but it's only in Queensland. Everywhere else, the deed can override that. Okay, that one's pretty straightforward. Oh, we're up to the last slide. Oh, excellent. All right, very last thing. Oh, again, another one. All right. What have we got on there? Yu Yang. Oh, we're looking forward to talk to you guys about Yu Yang. There's another case there. This willful negligence sort of. Okay, I didn't put this in here. Interesting. All right, it goes like this. Queensland, for some bizarre reason, has a different test for loss that's caused through the mistakes on behalf of the trustee. All right. Other states have willful negligence, which is a complete oxymoron. I've got no idea what that phrase even means. Negligence is completely different from willfulness. I don't know why. I think they've copied and pasted it from some judge's case, common law case. I have no idea. Either way, that's not the it's not the rule in Queensland. In Queensland, trustees aren't responsible for loss. This is caused by other trustees, unless they've somehow had a default. So before, when I said that when the trustees, one trustee will render the other ones liable, this is actually limits the scope of that liability, so that you won't be held liable because of Section 71 unless the loss has come through your own default. However, your own default is usually acquiescence. In other words, letting other trustees do whatever they like without checking them. That's sufficient to be considered your own default. All right, as part and parcel of that. Okay. Also note, and for whatever reason I haven't put it in here, I'm going to put it in the. I'm just going to write this up now. See if I can find it. Oh, don't crash on me! Don't crash on me! I might have had it earlier. I must have removed it. I'm not sure. Okay, come on, Chrome. Don't. Far out. All right, Themis holding the cane higher. Oh, where are you? Here it is. Okay, this case here. I want you guys to just note this case. Because I asked it, there's a discussion board question on it, that's why. So I'm going to plop it up in green. This is not to do with the trustees, actually lost in terms of negligence. It's Themis Holdings and Cane Hire. So it goes like this. You can put an exclusion clause in a trust deed that says trustees are excluded from negligence. Okay, so you can exclude. I'll write this out. You can. So the instrument, so it's will or the instrument can exclude liability in tort, or at least for negligent torts. All right, but never for fiduciary duties. Fiduciary duties. Fiduciary, or for breach, never for breach of fiduciary duties. Sorry about that. I'll put that in. I'll have to just update that slide. I'm just going to make the font really small. Okay, that's an important thing to note. So that, again, this is really for your guys' benefit when you are going to be possibly trustees at some stage and acting in capacity as accountants, possibly. That you can have in the instrument, and it'd be crazy not to put in the instrument that says trustees can be excluded from liability, have an exclusion clause in tort, all right, so that they can be held not liable for negligence, All right, that's a pretty huge thing. All right. However, it will never, ever stop you from breaching your fiduciary duties, which includes duties to be prudent and invest things carefully. So you make note that those two things, breaching things and negligence, can sound pretty similar to doing things. So the key takeaways is don't do things recklessly as part and parcel of that. Okay, so just make note. Again, I'll change these slides. I'll do it right now, actually. Oh, no, I won't. I'll do it when I finished. Give an example. Yeah, sure. If I've gone, and in fact, the previous slide has got the case. I've gone and invested, previous slide, all right, 2 slides back. Australian Securities Commission and AS nominees. All right, in that case, the people went and did an investment to buy some shares in a property investment company, and they looked at the prospectus but did no other research. Okay, so the trustees looked at the prospectus only and went and invested a whole bunch of money in it and lost all that money. There, in that situation, it was held to be a breach of fiduciary duty because you are not investing in low risk, low return stuff. All right, and it's going to be probably breach of negligence. Now, if you're an accountant, you're doing these things, you've got this idea of doing things using reasonable care and skill. You have a duty of care as a trustee, for your clients in that situation, to act and operate with the standard of care appropriate for a reasonably competent accountant or professional trustee. All right, and professional trustees are expected to know what they're doing more than people who are just assigned trustees because they said, oh yeah, put their hand up and said, I'm going to go through and do it. If you're a professional and you do something, your standard of care is going to be higher. You have to operate as at the level of a reasonably competent professional trustee. So if you don't, for example, know any of the rules that we've just discussed tonight, and you go and invest it in land banking in Oak Valley, and then you lose all of the money, you can be held liable in both tort and for breach of fiduciary duty as well. So just make note, if, however, you're not held duty for breach of fiduciary duty in that situation, all right, you might still be liable in tort if there's no exclusion clause in the contract because you've fallen below the standard of a reasonably competent professional trustee in that situation, because those things, because the tests are slightly different for the two sorts of breaches. The standard of care is going to be different. All right, now just make a couple of things, a few things to note. These last 2 things, I'm going to talk about Yu-Yang because again, I'm contemplating putting this on the assessment. So I'm going to talk about it because this is going to make your accounting brains pop, this case. For some reason, my law students were not that worried about it. I taught trust law. I was the trust lecturer last semester. And my students weren't too worried about this. You guys are going to flip out. Because it goes like this in Yu-Yang. So just make note that the tests, remember we had the test for causation and the test for remoteness in contract law and in tort law? Just make note, in equity, the rules are different. And they're crazy different. And I'm going to explain this here by explaining Yu-Yang. Because what happened with Yu-Yang is that it was a company, and in the early 90s, it was going, Minter Ellison was the trustee. All right, and when they were given instruction to go and invest in a particular investment, a particular company, they would issue a prospectus. Okay, and the way it was done is that Yu-Yang was to pay, or the trust was to pay, something like $260,000. All right, and so it was to pay $260,000, and in some years later, 10, 12 years later, they were to receive $500,000. Okay? I might just do this on the board. I'm going to do this on the board. It sounds funny when I say that. All right? So that they had the year. So 1993, they pay $260,000. And in some year, in 2003, again, I might be fudging the numbers here. I can't remember the exact years. They were supposed to receive 500,000. Okay, again, you guys can put your accounting hats on. You can work out what that amount is, but if it's whatever it is, 10% a year or something, I don't know, 9%. I'm not sure what it is. Look, I might be wrong with these numbers. It might have been 15 years. I'm not sure. Either way, that was perfectly fine. Now, there were two types of investment that they could have. There was the capital protected. All right, the capital protected fund, and or the ordinary fund. Now, went like this. Now, the reason why this was important is that the capital protected fund was set up that if the investment went badly, you would receive your capital back. In other words, the $260,000 back. Okay? Whereas the ordinary fund was just invested, like you would ordinarily invest something. So there's a chance you could lose all your capital. Okay? Does this make sense to you guys so far? Do the little buzzy thing if people that makes sense so far. Okay, so that's fine. So this makes sense. This seems pretty logical to you guys. Okay, sure. So Minter Ellison to the trustees, and Yu Yang's the company. They've paid, you said, $270,000. They're supposed to receive that 10 years later, $500,000. All right. Now, the capital protected fund means that they would be paid back, assuming the investments didn't go that well, they'd be paid back the $260,000. Okay. Yeah. All right. So, there was an error. All right, so the Minter Ellison, Morris Fisher, they made an error. They accidentally signed Yu Yang up and did the fund, all right, of this one here. They did this one here instead of this one there, which was what was asked for. Okay? So that seems pretty logical. Okay, so if you're the court, or if you're Minter Ellison, all right, and you've clearly mistaken, you've been negligent, it's clearly your mistake. All right. So the whole company, by the way, that they invested in went completely belly up. All right. So how much should Minter Ellison have to pay? In fact, I'll even put it as a little quiz. We won't ask it in the thing. I'll put it in the group. I'm going to put a little poll. I'm really interested to see what people say. All right. So assuming that they've been negligent, how much should Minter Ellison, what were they called then? Minter Ellison, Morris Fisher, MMF, have to pay? Oh, and this is in 2003. 2003, assuming. All right, so I'll put 0. I'll put 260, 260. And then I'll put 260 plus interest. We'll put 5. All right, we'll go with these things here. All right, how much do you reckon they should have to pay? So they've made this mistake, and what's happened? All of the money is lost. So if in this situation they had put the money, like not made this mistake, the money would have been lost anyway. Why? Because the thing they invested in, both the ordinary fund and the capital protected fund, all lost their money. There's no money left in that particular fund. The whole thing went broke. How much should Minter Ellison have to pay? Comment I'm really interested to see how. Oh, come on, it must be more than 4 years. Must be more than 4 years there. There's 15 people left in the group. 3, so we've got 200,000. Okay, I'm only getting a few years doing the response. Plus interest. Okay, an interesting split. It blew my mind when I had this one here, because the thing is, if we were using the but-for test for causation, all right, would what amount of harm would have come but for the breach? In other words, if these Minter Ellison had done what they said they were going to do, what was going to happen? If you're using the test in contract and in a tort, using the but-for test, what would have happened to Yu Yang if Minter Ellison did what they... If everything's gone, yep, if everything was gone. So assuming that Minter Ellison had put it in the capital protected. Remember, there's no money, so that not $1 got paid back out. All of the money was lost for all investors in both funds. Okay, all the money is gone.
Yeah, but if they would have signed the first one,
Yep.
which is the
Yep.
capital protection one,
Yep.
then they would have to supposed to give them back $60,000.
Remember that if they had done that and the investment was put in, they would have lost the whole lot because the whole company went broke in both funds. It was supposed to be.
But in the first option, if the investment went badly, you will receive your capital back. This is for
Yeah.
capital protection.
That's right. That's right. But it was paid by the entity that they were investing in. They said that, look, if our investment goes bad, we'll pay you back the funding. So that's what the people that they'd gone and invested in. It's not Minters saying they get the 600,000 back. It was the people that invested in, and there was an error, and so they'd invested in the ordinary one. But it turned out both funds lost all of the money. There was no money, so it wouldn't have mattered which they'd invested in. There would be no money at the end of it. Does that make sense? So it would have been, so in this situation, if Minters didn't make the mistake, so the but-for test, Yu Yang would have lost all of their money anyway. Okay?
Simon, I'm not understanding. Like you
No,
said,
I'll have to explain it. Yeah, that's right. So when back in,
suppose he did not make any mistake.
Yep.
Everything went the right way.
Yep.
While investing,
Yep.
it was agreed that if the investment went bad,
Yep.
you will receive your capital back.
Yeah, but the money's all gone. So they've agreed with that. So the company they've agreed with has done that, but the money's all gone anyway. It's all gone. No money.
Yeah, but they're still supposed to pay them back.
No, there's no money. No. The contract is with the investment, whatever the investment is. There's no money. So you can jump up and down and say, give us our money back. And they're like, well, there's no money. The contract is not, remember, with Minter Ellison. It's with the investment. So you've gone to the... Yep.
I said the fund, it's protected.
It says protected, but as it happened, all the money's gone. There's no money.
Okay, well, if it's protected, the people, the trustee, they are personally reliable.
Yeah. They...
If it's protected, it's their fault. That's, I mean, if it's their fault, it's not a trustee fault. It's them, because they didn't administrate properly. And that's, I mean...
Yeah, so what...
If it's $260,000...
Yep.
I think you put the wrong answer.
Yep.
Because we have to pay 260 plus the revaluation. That's the inflation. That's, I mean, it's the same amount of money.
It seems pretty logical. This is the thing. When I read this there, because the thing is here, if Minter Ellison hadn't made the mistake, Yu Yang would have lost all of their money anyway. So it didn't matter. So in terms of the but-for test, they would have lost all of their money even if Minter Ellison filled the form incorrectly, because the capital protected fund also lost all of the money as well. That no one got the capital back. The entity that they went in went broke and there was no money. So the difficulty there is the court, when doing it, we're trying to work this out. And this is why you guys are not going to love the logic of this, because the High Court said Minter Ellison had to pay Yu Yang $500,000. The test for causation and equity is not the same as it is in contract. It is not the same as in tort, And it is not even either reasonable nor, in many ways, logical for us as accountants to understand. This is why I said this. That's the really confusing thing, because what the courts say is that we will hold you as a trustee to a very high standard. Don't make mistakes. Now, even if, as it happens, this mistake wouldn't have made any difference, they would have lost the money either which way. They would have lost it even if they filled the form incorrectly. Okay? Test for causation does not work the same. It is all about putting the trustee into the hypothetical situation that they would have been in if things had gone properly. I know, right? Isn't that, does this seem like crazy illogical? Does that, I'm not going to ask, does that make sense? Because it kind of doesn't if you think about the way damages work in contract and the way damages work in tort. It doesn't sound very logical at all. It's because the court holds trustees to this very high standard. So essentially, this was almost put in a way, almost to punish them, if that's really the right word, to, yeah, try harder next time. That's what essentially the High Court said to Minter Allison in that case. Crazy, eh? Yeah, Hina, yeah, talk away. Yes. 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 Yep. 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 Yeah, that's right. But they didn't. Yep. Yeah, they were supposed to, but they spent it. They spent it. Yep. Sure, they're bound to. Yeah, absolutely. But they didn't. They spent it. And the thing is, what you find with a lot of these areas of law, going back to the deep pockets theory, you've got to work out where the money is. The company they invested in, the money's all gone. Well, the ordinary fund was that all of your things are supposed to be risk. In theory, the capital protected fund will be invested in such a way that if the investment doesn't go as well as we think it is, your capital will still be preserved. But in practice, all of it got spent. All of the money was gone. So that was supposed to be protected. That was the contractual agreement. But what happened was they spent all the money, it all disappeared, and there's no money. The thing is, when there's no money, you have to go and find people with money. And so here they sued Minter Allison Morris Fletcher, who has heaps of money, for them breaching their fiduciary duty in filling in the form wrong. And Minter Allison quite fairly said, well, look, even if we filled the form in properly, you still would have lost your money. And the High Court said, we don't care. You filled the form in wrong. You're going to have to compensate to put them where they would have been. I know. I completely understand if this seems absolutely crazy. The takeaway from this, though, is that causation in equity is quite different from contract and in tort, and it is set up in such a way so that everything is skewed to put beneficiaries where they're supposed to be. All right? Yeah, you know.
That's me.
Oh, Nathan, sorry.
In the beginning, you said under fiduciary duties,
Yep.
Beneficiaries are always getting the benefit.
Yes.
Right. So in this case, who is the beneficiary? Leon. Yulian.
Yes. Yeah, it is. Yes.
So why it is like complicated to think they what do you call? They want 500,000 from Ellison.
They want from Minter Allison because Minter Allison is the trustee.
Yeah, that's what I'm saying. Like
Yep.
it is not a
Oh, okay, good. That's good. It blew my mind when I read this because it if we think about the test and contract and the test and tort, they would have looked at this and said, okay, what would have happened if the other side did what they said they were going to do? Well, if they did what they said they were going to do, you would have lost all the money anyway. So therefore, you know, in theory, you wouldn't get anything if you were using the test. But in equity, that's not how it works. It literally isn't. It's crazy. I said I had a because yeah, I can't do it. I know, Hina. I feel your pain. I feel your pain. The idea is that the trustee is held at a very, very high standard to compensate beneficiaries. When a trustee makes a breach, the position that the beneficiary ought to have been in, and this is why, remember, trustees don't have a duty to invest in high risk investments, high returns, but trustees can be held, not always, all of these things are discretionary, the court chooses, to put you in the position as if things had happened properly. I know, it seems crazy. Yeah, you can talk. Yep, yep. They would have lost all the money. Yep. So the money would have been lost even if Minter Allison filled the form incorrectly. Mm. Well, it is. No, the thing is that the capital protected fund, that's the arrangement with the people you're investing in. That was the whole idea. And so that's what they tried to argue that, oh, look, this prospectus from this investment said, oh, yes, we're going to protect, we're going to have two classes of things. If the investment doesn't go, here's all the capital that we're taking off you guys, we're going to invest it. And if we lose a little bit of money, people that have got ordinary funds are going to lose their capital, a little bit of the capital and a little bit of the, not going to make much money. Whereas the capital protected funds, they'll be paid out first. But the thing was, that only works when they haven't lost all of the money, and they lost all of the money. And so the fact that there's a contractual right for Yu Yang to be able to ask this investment company for the money. Sure, it's a contractual right. It's an investment, though. There's a contractual right to ask for the money back. There's no money. And in that situation, oh no, who should we sue? Well, the trustee is breached by making this clerical error. Should we sue them? Yes. How much money? The court, and the thing is, Minter Ellison admitted negligence. They said, yeah, we got it wrong. We got it wrong. We made a mistake. But surely, logically, we can't be held responsible because if we didn't make the mistake, they would have lost all their money anyway. The High Court said, no, mate. No, they said, no. You're actually going to have to pay the higher amount. Why? Because we, in our legal system, make trustees have a very, very high bar for doing things properly. In a situation like this, where there's a loss, we are essentially reallocating from a trustee in breach to a beneficiary. We're doing it for policy reasons. Try harder next time. That's essentially what that decision says, which is a little bit scary. Like I said, the accountant brain in me. Is it fiduciary applying for trustees? A trustee is a type of fiduciary relationship. So trustees have, again, if you guys are accountants, if you're going to be a professional trustee, you're going to have, it's you're going to have fiduciary duties and you're going to have professional duties in tort and in contract as well, because you can have multiple duties. If I'm an accountant and I operate as a professional trustee, I'm going to have a duty of care to operate as a reasonably competent accountant, a reasonably competent professional trustee. I'm also going to have contractual obligations, assuming that you're paying me to set this thing up, to make sure I do that right. So I'm going to have obligations and contracts, and I'm going to have fiduciary duties as a trustee as well. All right, but these ones, that Themis and Canehire case, you can't contract out of those. You can't exclude liability, which you can do for all of these other ones, and the contract can exclude that. You can never exclude fiduciary duties, and they hold you to a really, really high standard as a result. So just make note, the test of causation is crazy in equity. It's crazy. You can also get compound interest as well, which you don't get at common law. You can get it in equity. All right, I'm going to leave that there, guys. So it's running a little bit late, but I'm just going to quickly change that slide to put that Themis and cane hire case on it. I hope that was useful. Like I said, this is stuff that I wish that I had. You're probably going to have to go over it again, I would imagine. So you may have to go through this second recording tonight to go through that twice. And yeah, and I hope if you guys do go up into practice as accountants, that you're actually going to get some of this. And look, it takes a little bit of time to get used to it, particularly some of these tests. They're a little bit crazy. Yeah, Hina.
Just wanted to tell you, Simon, you have some students who are not becoming accountants,
Yes.
who are not becoming lawyers because we are just doing MBA leadership
Yes, I know.
with a management job.
This is true.
Not become accountant. I'm not
Okay.
becoming
Well,
normal job.
if you are living and working in any of the common law jurisdictions, so Australia, New Zealand, United Kingdom, Canada, United States, and you're planning on owning stuff, because trust and trust law, and one of the discussion questions is this: trust law has been referred to as a vessel of evasion. Why? Because rich people can use it. Because if you think about it, trusts involve property. You can't use trust and trust law if you don't have property, if you don't have stuff. And managing stuff to suit your particular purposes, to suit your family arrangements, to suit your tax situation, knowing how to plan these things is important both in your personal life and also in professional life as well. Particularly for if you're dealing with small entities, and you're having to do and make management decisions involving those entities, both in terms of a commercial, contractual sort of relationships, but also in terms of going and knowing how the structures work. It's also important for things like superannuation, self-managed super funds when you're doing them yourself, because the rules of trust law, remember I talked about the rules of common law for contract and you've got statutory stuff? Well, it's the rules of trust law modified by the superannuation statutes as well. And so all of these things are things to think about for you guys going out into the world. And either I'm not going to make any comments about where people are at in terms of sort of wealth accumulation, but over time you're likely to accumulate wealth, and how you manage that, particularly that slide where I talked about those 8 different things to do with why you might set a trust up. It's always helpful to know and understand this stuff when planning your own assets, and planning and knowing when people talk about trusts, how and what they're meaning here. It's all really, I think all this stuff is really about power. It just makes you more powerful as a person, knowing this sort of stuff, in my mind anyway. But anyway, I'm going to leave it at that. I've got a whole bunch of things I've got to run around doing. So I will, again, by close of business tomorrow, I will have feedback for those that have submitted the feed forward. And I said I'll probably just put up a little brief of what I've learned or gleaned for the whole class's benefit as well as that little document I put up today. Okay, thanks team. Hope that was useful. I'm going to stop the streaming now.